again with Brian Schneider from Hudson Injury Law. Brian's been helping clients across the Hudson Valley in New York City for years. And today we're diving into a topic most people don't think about until it happens to them. I was just talking to a friend the other day who was injured in a car accident, Brian. The other driver didn't have insurance, but luckily the car they were driving was insured. So the outcome for her ended up being a good one. But it made me think about all those cases where people aren't so lucky and there's just no insurance at all. Now, you've handled your share of these situations, some with great outcomes and some where recovery just wasn't possible. What's the most important thing people should understand when they find themselves in that position?
Thank you, Jean. So yes, your friend who got into the car accident with an uninsured motorist was fortunate. Here in New York State, there's at least minimums required of uninsured motorist coverage and underinsured motorist coverage. And I would refer our viewers to some previous videos we've done on that subject. I don't want to wade too deeply into that again, but it's likely that she got some help or some relief through her own coverage or the car that she was riding in at the time. What happens, though, when people get hurt? Maybe they trip and fall on a property and the owner doesn't have homeowners insurance or an appropriate landlord policy. Or another common one is the brawl or the fight at a nightclub or a bar or a restaurant, which also may or may not have insurance. What are the options then? Well, I want to be upfront with you and anyone who's watching this. My retainer agreement for negligence cases, personal injury cases, much like every other or many other personal injury lawyers, provides for a withdrawal provision, meaning if there's no coverage in a case, most attorneys who do what I do reserve the right to withdraw from representation. But it's not going to be a surprise to most people when I explain it to them. If there's no opportunity for a recovery financially, there's really no point in going forward and spending money endlessly and fruitlessly to achieve what we would call a Pyrrhic victory. Like, it's, yes, you win, but the win might not be worth the paper it's printed on. However, and this is a big however, there are situations where it might make sense to go forward against someone who's uninsured. And if you just permit me a moment, I'll explain some of my historical examples on the subject. I represented a woman once who was injured in what was called the social club. It's basically think of like a VFW hall or a Masonic temple, something like that, where it's a group, an organization that might own a place that they have a modest bar at, for example. So she was injured in an incident in one of those places, and they were uninsured. So I opted to go forward with that. The defendant in that case never answered anything, didn't respond to any certified letters, didn't respond to the lawsuit that I filed, didn't respond to what's called the motion for default judgment, where you ask the court to give your client a victory on default because the defendant has ignored all of their obligations. I want to get into the process a little more, but long story short there, we entered a judgment. And about a year or two later, I get a set of papers and a response from a lawyer on behalf of, guess who? That social club or that social hall owner. He or she was a businessman. He wanted to do some business. And for whatever reason, this judgment that we entered and filed against this corporate shell or this entity, he could not get out from under it without dealing with us. The ultimate resolution involved him paying a pretty handsome amount to satisfy that judgment. My client was obviously happy to get something out of nothing. So you have to sometimes be selective and pick your battles carefully, because a lot of times, even if you think you've pinpointed one that's good, it doesn't always turn out that way.
You are, in that case, the defendant, and you are getting certified letters and so on and so forth, and you just don't respond. Curiously enough, is there any penalties for that?
It's a great question. So a lot of my letters, a lot of them contain form language. When you've been in practice for 26 years, you kind of fine tune your letters for the situation. But oftentimes there is all sorts of gloom and doom or fire and brimstone type language. If you don't do this, this is going to happen. If you don't do that, this is going to happen. Is someone who is simply ignoring or defaulting on these things going to be penalized directly by like the state of New York or the city of New York? No, no. There's no criminal implication for blowing off civil lawsuit papers. However, you do run the risk of having what happened in that one example I just shared happen to you. You will have a judgment entered against you. And outside of a bankruptcy, and this has always been my understanding, but people who do debt collection and enforcement would know more precisely than I, but outside of a bankruptcy, a judgment is about the worst thing you could have on your credit. It's going to make it very difficult to get a mortgage, get a new credit card, get a car loan, because that thing is going to be like a flashing red siren, to any lender who you've approached to try and borrow money from, I should say. So it's very, very unflattering, to say the least, to have a judgment of significance entered against you on your credit report. It makes doing business on an everyday basis, like you and I try to do, very hard.
Right. So ignoring it doesn't make it go away. And that's basically what you're saying here. So even though those whether it was the VFW or the Masonic Temple, they ignored it for 2 years, it didn't go away.
Exactly. Right. So someone can, do what I did in several examples, and we go through this entire process, and I'm going to detail that in a little more precisely in a moment. But then a judgment's entered. And then, usually at that point, I'm saying goodbye to my client, and I'll say, hey, listen, if we ever hear from anybody about this, I'll let you know. So let me go off on one other tangent first, though. There are lawyers who make it their point when they get a judgment on the books. They can do things. There are options available. You could send subpoenas to someone's bank if you know where the banking might be done by the defendant, and freeze their accounts. You can send information subpoenas to a defendant's employer and try to garnish wages. There are absolutely steps that can be taken. I typically haven't gone to those lengths for a lot of reasons that are probably beyond the scope of this video presentation. I'd be happy to take any conversation like this offline for someone who is interested in. But when it comes to, okay, I have a property where something went wrong, right? A wrong was committed, a negligence or a negligent act was performed. Sometimes just knowing that a defendant owns a property signals a couple of things. One, they might have some money. Maybe they'd be willing to pay something out of their personal assets or proceeds to satisfy a case. I've had that case too, where people are uninsured, but they're plenty successful. They're plenty well off, and I know they have assets. And then I get a call from a privately retained defense attorney versus, say, like an insurance company provided lawyer, and I know who's who. And sometimes you can do business with defense counsel in those cases, much like you can on a regular insurance case. But again, these are exceptions rather than rules. Usually when you have someone who's uninsured, usually when you have someone who's defaulting, the two-word phrase that we don't want to hear usually comes to mind, like someone who's judgment proof, right? You can get $1 million judgment, you can get $100,000 judgment, a $10,000 judgment, and you'll never see a penny from it.
Isn't that kind of like OJ civil lawsuit?
Right. Yeah. Yes, exactly. OJ was obviously, very, he was at his heights. He was a movie star. He was an all-star, Hall of Fame running back. He had money. He had endorsements. All that obviously went up in smoke once he got into trouble with the law. And the Goldman family, and I think Miss Brown's family, took that very substantial personal judgment against him. But yes, they were going to make it a point to collect as much of that as they possibly could. Well, he had assets, though. He owned homes. He had money. He had the Heisman Trophy stuff that got him into trouble again. So yes, he was a high-profile defendant. That's, again, the exception and not the rule.
And where else does this happen in personal injury law? Because I think we often think about car accidents and, like I said, I had a friend and the driver was uninsured and so on and so forth. But you've been handling personal injury cases like this across all types of like slip and falls, dog bites, and all that. Are there other areas where this no recovery problem comes up a lot?
Well, the most common ones are definitely the nightclubs. There are a lot of fly-by-night clubs that are just, charging covers and, charging whatever they mark up their booze and their liquor. And they're not, paying attention to some of the other basic overhead necessities that a more traditional establishment would look for. So that happens a lot with nightclubs and also with clubs and bars. There's different types of coverage. It's not just a regular liability policy that's always going to be in play with, say, an incident at a bar. It could be a liquor liability policy you might need a liquor liability policy in play in order to make a recovery for someone who might be, for example, overserved. There are instances where it can be a little more common. Another one, actually, you and I think, had this conversation in an email exchange, like people who are tenants and they own dogs and they might not have a renter's policy. That can prove problematic sometimes. And then, someone like myself would have to shift focus from the tenant to the landlord. Maybe the owner of the property knew something about the dog or had some knowledge or should have had some knowledge that this dog was a problem, or maybe had seen something problematic with the dog, him or herself. Sometimes you have to adjust your sights, if you will, to try and make the best of a bad situation. But those situations, in my experience, have been the most common. The nightclub scenario, the bar scenario, or the uninsured tenant who has a dog that unfortunately does harm to somebody.
Brian, how does it complicate things if you find that you're dealing with an LLC or a shell corp or a corporation? So the entity that owns the building isn't a person or someone that but it's owned under, a corporate ownership. Is that handled differently, or is there just more investigative work up front to figure out who might be that corporate entity?
Interestingly, right, if there is an LLC, if there is a company, like a corporation behind, say, a property ownership, that might at least lend itself to reason that, hey, maybe there's someone who's got some money that cares about this. Now, a lot of times people who form LLCs or, like you said, a shell company, they're doing it simply to protect themselves from personal liability. Doesn't always mean, of course, that there's going to be, a pot of gold or a bunch of money behind the company backing it up. But it might invite a little more investigation and a little more scrutiny as to why a company is blowing off a set of papers or why a company is blowing off these letters. Usually if it's a traditional case, someone, trips and falls somewhere and it's an LLC that owns a building. Yeah, I'm going to file those papers. I'm going to file that lawsuit. I want to invite a response. I want to draw them out from under the rock, if you will. Let's see what we're dealing with. It does take a few bucks to marshal a case through an uninsured situation or a situation where a defendant has defaulted. And actually, this is a good segue now. Let me explain how this works procedurally. You file a lawsuit. The law gives a defendant a certain period of time to respond. If they don't respond, you can file what's called a motion for default judgment, where you ask the judge to say, hey, judge, listen, we did A, we did B, we served C, we served D, we filed D. Here's our proof that we are playing by the rules and the defendant is ignoring us. More often than not, you will have that motion granted. And then what happens after that? Well, then you still need to prove your case. You and your client, or my client and I should say, would still need to go to court, present medical records, testify about what happened. We still need to prove our case in a satisfactory way to the judge at what's called an inquest. An inquest, quite honestly, is just a fancy term for like a one-sided trial. This still happens. You're not going to get a jury, but the plaintiff or the injury victim needs to testify. I still need to lead him or her through questions. I still need to submit medical documents in evidence to sustain or to at least corroborate the claim of injury. And at the end of all that, the judge will ask us to make a demand. What's your requested relief, Mr. Schneider? What is Miss Smith looking for? $1 million, I'll say, usually in those instances. And then the judge will make a decision, usually award us based on our presentation. And then that number and those things get reduced into what's called a judgment, which is just a fancy word for a bunch of papers that got to be filed with the county clerk. Boom. That's when things get real for the unresponsive defendant. A judgment is now on the rolls. It's a public record. Banks are going to see it. Credit card companies are going to see it. Anyone who's in financing and trying to get into business with that unresponsive defendant, they're all going to see it. And that's when you hope at some point you draw a response. And there's some ways that happens. Oftentimes lawyers will call up, hey, Mr. Schneider, I represent this defendant that blew you off. Because is there something we can do to maybe, get this judgment off the books? Can we satisfy? Can we settle? Or they'll file a motion to vacate the judgment, and we can kind of parry and fight and squabble while that's pending. That's typically been my experience, and sometimes it does, yield some nice fruit. And those are always blessings in disguise for clients, because most people in those situations are conditioned to believe, nothing is ever going to come of it.
And what about construction site injuries? What about smaller contractors, sometimes operating without valid insurance? These, cases are complex, and we look for, every possible third party who might possibly, right, have some liability or some coverage in this.
So you're right. You're not likely to see that as often as you would say, like with the bar or the nightclub scenario that I identified. However, I have a case right now, right this moment, where I represent a young man who was injured on a very substantial job. It was a big job upstate, and he happened to be working for a subcontractor local to us. And the subcontractor, I think they did drywall or sheetrock. And I have no doubt that the general contractor and the owner on this very substantial project would have required in a contract all sorts of insurance coverage. It's there in black and white. They would have absolutely been required to produce coverage, but they were probably never asked to produce it. There is no coverage likely for this company in this instance. So this young man is injured on the job. It's going to complicate his workers' compensation situation. Excuse me. However, he absolutely still has a claim against the owner and the general contractors in those cases under the labor law, which we talked about in one of our other videos. So I would refer anyone who's interested in that to go look at the construction accident and the labor law 240 video we did a few weeks ago. So it's rare, but it does happen. In my experience, if you're going to deal with the uninsured contractor sort, it's more likely to appear at like the single family homeowner situation, like a handyman.
Just going to ask about that. Yeah.
Yes. Because here in the Hudson Valley, it's not as rigorous as, say, New York City or Westchester. There's not as much of a requirement for licensure or, county issued permissions. Dutchess County has some, but it's not as prevalent as it is in New York City. So yes.
Okay, someone who might come to work on my property and gets hurt on my property doing the work, I'm liable for that.
Well, not necessarily. Like it could be something that's contested, but if as a homeowner, and this would just be, standard advice, if you're engaging a contractor to do any significant work on your property,
like taking down a tree or something.
Perhaps, yeah, you could ask for what's called a certificate of insurance. Yes, you want some sort of proof that they are insured. Absolutely. But even it will become more important if someone's like putting an addition to your home or knocking down walls in your home, and God forbid something goes wrong, right? You're going to want to make sure that company, that individual has some handy or some proof of insurance. So, typically you'll just say, hey, can you give me a certificate of insurance? I want to see that it's current. I want to see who you're insured with and what your coverages are. So yes, if something goes wrong, you have some measure of security.
A lot of curious things there about that you're making me think about when homeowners have people come to work on their property. Things I think that we don't think about, but there is liability there.
Yeah, listen, and it's even if it's not liability, right? Even if some contractor or handyman comes on your house, onto your property, into your home, and something goes wrong during his construction, I mean, your insurance company, you'll have homeowners, but they're going to be looking to pick the pocket of his insurance company. And you want as much layers of coverage as you could have under those circumstances. But yes, what happens though if the handyman has a coworker who, falls off a ladder, right? And they have no insurance. Where does that leave you? Well, yes, it could leave you in someone's crosshairs. I'm not saying it's going to be easy for them. With workers' compensation out the door, well, a lot of people might feel desperate and, maybe they get someone to help them try and make an effort to recover against something like, your homeowner's coverage. And it gets convoluted, and by no means am I suggesting that's an easy path, but desperate people are going to try desperate things sometimes.
And actually, I was just thinking about the fact, the next thing I wanted to bring up was hit and run accidents. And it's actually interesting. I've been driving in and out of Manhattan for 15 years. And I was saying to my daughter-in-law, we were in the car together and we went down to see a show in Times Square on a Friday night. And, we stopped at a yellow light. I think everybody in Manhattan thinks that, you just run every yellow light in hopes it doesn't turn red. But we stopped. But the car behind us decided to go around and swiped my car and went on through the red light and took off. And, in that sort of case, I mean, the damage was minimal to my car. And so I wasn't going to pursue anything. But in those sort of cases, what should somebody do if there's some, damage to the car or someone got hurt and it's a hit and run accident? What do you do in those cases?
Gotcha. So again, this kind of falls back onto that uninsured motorist coverage we've talked about before, but this is a perfect refresher opportunity. If you're struck by a hit and run vehicle, you have two primary things you need to do right away. You need to, one, notify the police and get it documented. And two, you have to show that there's some measure of physical contact between that offending car and your car. So obviously, damage to the car that's visible, that's observable, is a no-brainer. Sometimes, though, there are situations where physical contact can be proved in other ways. A tire, for example, dislodges from a tractor trailer and bounces down the highway, and that tractor trailer just keeps going on its merry way because it's got 17 other tires, right? And it smashes through someone's windshield. Those are horrible, horrifying cases. But the one you're talking about is a little more bread and butter, right? Some deadbeat essentially just wants to, flee the scene so he doesn't get tagged for any troublemaking, and then you're left high and dry. So call the cops within 24 hours of the accident, get it documented, and be prepared to prove that there's some, measure of contact that occurred between that hit and run vehicle and your vehicle.
Okay. Right.
But let me actually, if I may, that actually, there's another layer to this that we didn't talk about in our previous videos. The MVAC, the Motor Vehicle Accident Indemnification Corporation. What is that? So let's just say you're a pedestrian, right? You live in Manhattan. You don't own a vehicle. Your husband doesn't own a vehicle. No one you live with owns a vehicle, and you're struck by a hit and run vehicle. What is your option then? Well, you could file a claim with MVAC. It's kind of like a safety net for, of last resort for people in those circumstances. There are very tight deadlines with filing a claim against MVAC or with MVAC for medical bills associated with your accident and for personal injury, for like the pain and suffering that you will undoubtedly suffer after being hit by a car. The limits are limited. The time frames are very, very tight. So again, if someone wants to take this conversation with me offline, I can fill in those details more precisely. But that's kind of like the ultimate last resort for people who have no other means of recovery in those situations, which is different from like your situation when you went to the city. You own a car, you were driving it, you have insurance. That's your backstop. But if you're that tenant in an apartment building in Manhattan and you haven't driven in years and there's no reason for you to have a car and you get struck by a hit and run vehicle, this MVAC option would be there for you in those circumstances. It's not ideal. It's not going to necessarily solve all your problems or make you incredibly wealthy by any means, but at least it's something.
Yeah, and I think one of the points that you hit on, Brian, is that it isn't always about a substantial settlement, but it's about getting coverage. If you have debts, you have health care bills and things like that, that's what you really want to at least try and get covered. And it sounds like what you're talking about with the MVAC, at least it would cover some of that.
Oh, sure. Yes. There's coverage for medical bills like there would be for a regular no-fault policy. Mm-hmm. But yes, there's also an opportunity to make a pain and suffering recovery as well. And what will happen there is that MVAC will have lawyers, like any insurance company would assign lawyers to defend their customers if they were responsible or potentially negligent in those circumstances. It'll proceed the same way. The constitution of the case, if you will proceed the same way. You'll file a lawsuit. You'll have a deposition. If you can't settle it, you go to a trial. It happens. It follows the same path. It's just that you're dealing with lawyers for essentially what's a quasi-governmental type of fund to try to make a recovery. But you're right. Even if there's not going to be a lot of money to recover for pain and suffering, having those medical bills and if necessary, potentially lost wages reimbursed is usually at least some measure of relief to the person who gets struck by a car that just doesn't own a vehicle of his or her own.
These are all tough cases. And I think what you are helping me to understand, and hopefully many of the viewers that are going to watch these videos, is that your service of that initial call, there's no charge. And so what we're really getting to here is that it's a very complicated legal system this day and age. I mean, we've become a very litigious society. There's a lot of different aspects. So basically, it doesn't hurt to pick up the phone and call a personal injury lawyer like you and ask some questions.
Absolutely not. Right. I don't charge for, phone consultations or even people who take it a step further and want to meet either over Zoom or online, whatever they're most comfortable with. Yes, because sometimes you just don't know. Sometimes it just takes a meeting. Again, whether it be online or in person, just to try to really uncover and make sure that all options have been exhausted. Again, these are not going to present as the strongest cases. These are not the big ticket, sexy cases that every lawyer hopes are going to fall in their lap. But oftentimes, just showing people the courtesy and the respect of just at least giving them an opportunity to explain themselves, even if you can't help them, in my experience, that's something that they remember, and maybe, who knows, they come back to you, God forbid, they are in need once again, or maybe they have a friend or a colleague or a family member they refer to you who you can help down the road. But more to the point, sometimes you don't know what you're going to find. And it takes some tenacity, it takes some urgency, and it takes some sincerity just to try to uncover it. So you can at least assure the person who's called that you've given it a thorough once over, you've done what you can, and you move on from there as best you can.
And basically, in the end, knowledge is power, and you're just a phone call away.
There you go. I can't argue. I can't argue with any of those things. So, right. Yeah, by all means, people are welcome to call if they have questions that kind of fit into this subject that we've been discussing today.
Well, thank you, Brian. And to anybody who's watching, if you have questions or there are some topics that you would like to see us discuss on some of these YouTube videos, please put it in the comments or hop on over to Instagram and Facebook and message Brian, and we'll try to cover some of the topics that might be of interest to you. Thanks.
Thank you, Jean.